Now, before you think this is just gossip or wild guessing, let me make something very clear. Everything I'm about to show you is real. Court papers, legal agreements, Supreme Court orders, all of it is public. You can look it up yourself. No secret sources, no rumors, just facts. Here's what just became official. Melania Trump has given up something called spousal privilege. This is a legal shield that usually stops prosecutors from forcing a husband or wife to speak against each other, but she's giving it up on her own, willingly. And the evidence she's offering, it falls into three main areas. First, financial records that show she knew about fake property values. Second, messages and emails about property prices and loan papers. And third, her own story as a witness that matches what accountants and bank workers already told the grand jury under oath. Because the Supreme Court said no to the appeal, there are no more chances to fight this. No more delays, no more legal tricks. The grand jury could hear what she has to say within just a few days, and here's the timing that matters. Her former husband has a confirmation hearing coming up. It's scheduled for early March. That's only 6 weeks from right now. Let me walk you through what happened over the last 3 days. Because when you see the order of events, you'll understand this was all planned. I'm going to keep covering every single update in this case as new facts come out, not guesses, just the truth. If you want to follow what's really happening without all the media noise, make sure you subscribe. Let me start by explaining the timeline. On Monday afternoon at 2 p.m. Eastern Time, Melania Trump's lawyer filed a document with the special counsel's office. It's called a Proffer agreement. Let me explain what that means in simple terms. The legal system uses words that sound confusing, but the idea is actually pretty basic. A proffer is like a preview. The witness says, here's what I know, here's what I can tell you, here's the proof I can give you. And in return, prosecutors think about giving that person immunity. That means protection from being charged based on what they say. This kind of thing happens all the time in federal cases. Witnesses offer information regularly. But what makes this situation so important is who is offering the information and what exactly she's willing to share. 24 hours later, on Tuesday afternoon at 2 p.m. Eastern, exactly one full day after the proffer was delivered to prosecutors, the defendant's legal team did something urgent. They filed an emergency appeal to the United States Supreme Court. They're asking the court to stop her from testifying to the grand jury before she even gets the chance. Their legal reason? They claim that forcing a spouse to testify breaks marital privacy rights under the Fifth Amendment. That was fast, really fast. Most emergency appeals take weeks to put together. This one showed up in just 24 hours. That tells me something important. The defense team was ready. They knew this was coming. 48 hours in, on Wednesday morning, the Supreme Court officially accepted the appeal. They gave it a case number. They put it on the schedule for review. But they didn't issue something called a stay. A stay would mean stop everything until we make a decision. No stay means everything keeps moving forward while the court thinks about it. That silence is important. When the Supreme Court puts an immediate stop on things, it's a signal. It means the justices think the legal argument might have some value. When they let the process keep going, it means they're doubting the argument. 72 hours in, this morning at 10:03 a.m., the Supreme Court gave its answer. One sentence. Application denied. No one disagreed. Justice Thomas didn't disagree. Justice Alito didn't disagree. Justice Gorsuch, Justice Kavanaugh, Justice Barrett, all judges appointed by Trump, none of them disagreed. Everyone agreed to reject it. When the court writes even a short opinion, it means the legal issue needed some explaining. But when they just write one sentence with zero disagreements, it means the appeal wasn't even worth talking about. I've watched cases for over 30 years. I've only seen this level of rejection 3 times. And each time it meant the legal argument was so weak, the court didn't even need to explain why they rejected it. So that's what happened over 72 hours. Proffer filed on Monday, emergency appeal filed on Tuesday. Court accepts it but doesn't stop anything on Wednesday. Application denied on Thursday. Now let me show you what's actually inside that proffer agreement, because the evidence she's offering is bigger than what the news headlines are saying. The proffer agreement lists 3 types of evidence. Let me explain each one, because when you put them all together, it becomes very serious. First type, financial documents that show she knew about fake property values. She signed joint tax returns from 2014 to 2020. That's 6 years of tax papers where both husband and wife sign and promise under penalty of lying to the government that the financial information is correct. Those tax returns depend on property values, what the properties are worth, what money they make, what deductions they can claim. If those values were made bigger when talking to banks to get loans, but made smaller when talking to tax authorities to pay less taxes, that's bank fraud and tax fraud. And when you sign a joint tax return, both people who sign can get in legal trouble. The proffer shows she was in meetings with accountants where they talked about how much properties were worth. She asked questions about how the properties were being reported. That's proven in emails that prosecutors now have. Second type, communications, text messages between her and the defendant talking about property values before they met with lenders. Emails with accountants where she asked questions about differences between what was being told to banks and what was being told to tax authorities. And phone conversations that were recorded, yes, recorded, where they talked about values for specific properties when applying for loans. Let me be clear about recordings in federal cases. If she recorded conversations and followed the law, those recordings can be used in court. If she's offering them in a proffer, prosecutors have already checked that they're real. Third type, witness confirmation. She can back up what the accountants already told the grand jury. She can confirm what the bankers said under oath. She can support what the property appraisers said about being pressured to make values look bigger. In federal prosecutions, confirmation is everything. If one witness says, "I was in a meeting where we talked about fake values," that's strong. If a second witness says, "I was in that same meeting and here's what was said," that's confirmation. If a third witness brings documents from that meeting showing the fake values, that's a pattern of proof that becomes very hard for the defense to fight. Now, here's the legal earthquake hidden in this proffer. She's giving up spousal privilege. In most cases, a husband or wife cannot be forced to speak against their partner. It's a protection based on the idea that marriage needs trust, and the legal system shouldn't break that trust by forcing someone to testify. But, and this is the key point, spousal privilege can be given up voluntarily. Her proffer agreement has clear language in it. Privilege is hereby waived for all matters covered in this agreement. That's not prosecutors forcing her. That's her choosing to give evidence. I've seen spousal cooperation in organized crime cases, wives of mob figures who testify to protect themselves. I've seen it in business fraud. The wife of an Enron executive who cooperated after she realized she could be charged too. But this is the first time at this level where the defendant held the highest position in the country that a spouse has come forward with financial documents, communications, and her own testimony. That's what she's offering. Now, let me explain why the Supreme Court rejected the appeal so completely. The defendant's emergency appeal had 3 legal arguments. Let me show you why each one failed under the law that already exists. First argument, spousal testimony breaks marital privacy protections under the Fifth Amendment. But there's 150 years of Supreme Court decisions that say spousal privilege can be given up voluntarily. The most important case is Trammell versus United States, decided in 1980. The court said that the witness spouse holds the privilege. That means the decision to testify belongs to the witness, not the defendant. If the witness chooses to give up the privilege and testify, the defendant can't stop it. That decision has never been overturned. Every circuit court in the country follows it. The legal argument had no foundation. Second argument, the Proffer agreement was forced through threats or pressure that made the testimony not voluntary. But the filing includes a sworn statement from her attorney saying she contacted the special counsel's office first, not the other way around. Her lawyer reached out. She proposed cooperation. They negotiated terms. No subpoena was sent. No threat was made. The proffer was her choice. Federal courts have a clear standard for whether something is voluntary. Was the witness threatened with charges if they didn't cooperate? Was evidence of their own crimes used as pressure? If the answer is no, if the witness came to prosecutors on their own, the cooperation is voluntary. The sworn statement eliminated any claim of force. Third argument, allowing this testimony sets a dangerous example that will destroy marital privacy in future cases. But the example already exists. Spouses testify in federal cases all the time when they choose to. The Trammell decision settled this in 1980. What the defense was really arguing was create a new exception to the law because of who the defendant is. The Supreme Court doesn't create exceptions based on who someone is. The law applies equally to everyone. So when the court issued that one-sentence rejection, application denied with 0 disagreements, that told me everything. The legal arguments weren't just weak, they were pointless. I know what the standard is for emergency appeals to the Supreme Court. You need to show 2 things: harm that can't be fixed, and a strong chance you'll win on the legal question. This appeal showed neither. The harm, which was testimony being heard, is just the normal way the justice system works. And the chance of success required overturning Trammell, which no justice was willing to consider. The Supreme Court just removed the final delay tactic. So let me show you what happens next in the courtroom, because the timeline just sped up. That's why the Supreme Court rejected the appeal in 1 sentence. Now, let me show you what this means for the trial itself, because the timeline just changed in a big way. With the Supreme Court appeal denied, the grand jury can now hear her testimony within days. The grand jury in this case meets on Tuesdays and Thursdays. That's the normal schedule in federal court for the Southern District of New York, where this case is being handled. If prosecutors are ready and the Proffer agreement suggests they are, I expect her to appear before the grand jury within the next 7 days, possibly this coming Tuesday. Once her testimony is finished, prosecutors have to make a strategic choice. Let me walk you through the 2 options, because this decision will determine what happens at trial. Option 1, use her testimony to make the existing charges stronger. The current indictment includes 34 counts of falsifying business records and bank fraud. Her testimony about signing joint tax returns, being in meetings with accountants, and confirming what other witnesses said, all of that makes the prosecution's case stronger on charges already filed. Option 2, ask for a superseding indictment with additional charges based on new evidence she gives. Here's what I'm watching for. Her proffer mentions a specific conversation from March 2020. She was there during a phone call between the defendant and a banker where property values were discussed before a loan application. If that conversation included coordinated false statements, him saying one thing, her confirming it, both knowing it was false, that's conspiracy to commit bank fraud. Conspiracy is a separate crime from the fraud itself. It requires an agreement between two or more people to commit an illegal act, plus one clear step toward that goal. A phone call where both people knowingly make false statements to a bank, that's the agreement. Filing the loan application, that's the clear step. If prosecutors believe they can prove conspiracy based on her testimony, they'll ask for new charges. A superseding indictment would add counts and possibly increase the defendant's legal risk. The trial is currently scheduled for September 16th. That's 28 weeks from today. With the Supreme Court appeal denied, there are no more delay tactics left. No more emergency motions to block evidence. No more privilege claims to fight over. That date will stay. Let me know in the comments, based on the timeline I just showed you, do you think her testimony leads to more charges, or is this about making the existing case stronger? I'm curious what you're seeing in the evidence. Now, let me show you why this matters beyond just one trial. This case sets 3 examples that will affect federal prosecutions for many years. Let me break them down, because the effects go far beyond this defendant. First example, spousal cooperation at the highest levels of power. I've seen spouses flip in mob cases. In the 1980s, organized crime prosecutions depended heavily on wives who testified against husbands to avoid their own charges. Sammy Gravano's wife cooperated. So did Henry Hill's wife in the case that inspired the movie Goodfellas. I've seen it in corporate fraud. During the Enron prosecutions in the early 2000s, several executive spouses gave testimony. Some did it to avoid charges themselves. Others did it because they realized the financial risk was shared. But we've never seen this at presidential level. The spouse of someone who held the highest office in the nation coming forward with financial documents, communications, and testimony that directly connects that person to federal crimes. That's new legal territory. And it changes the thinking for future investigations. If you're a federal prosecutor building a case against a powerful official, and you know the spouse has shared legal risk because they signed documents or were in meetings, you now have Supreme Court precedent that says spousal privilege can't block voluntary cooperation. Second example, the Supreme Court speed shows that privilege claims won't delay federal prosecutions. The one-sentence rejection, application denied with 0 disagreements, just set a marker. When spousal privilege is voluntarily given up, emergency appeals based on marital privacy will not work. Courts will not allow delay tactics disguised as constitutional arguments. That matters for every future white-collar case where spouses have shared financial risk. Defense attorneys know now that privilege claims are not good delay strategies when the witness chooses to cooperate. Third example, accountability applies no matter how much wealth or status someone has. For many years, wealthy defendants used procedural tactics to drag out cases, appeals, privilege claims, emergency motions, hoping to outlast prosecutors or wait for political changes that might stop investigations. This case shows the system can still work when judges and courts move with purpose. The judge in this case has kept a strict timeline. The Supreme Court rejected delay tactics unanimously. The grand jury process continues without stopping. If you've been frustrated watching powerful people avoid consequences through endless appeals and procedural games, This is what accountability looks like when the system refuses to be played. The court said no, the judge said no, the law applied equally. The system worked today because institutions held strong. Now, let me tell you exactly what I'm watching for in the next 30 days, because 3 specific developments will tell us where this case goes. Those are the stakes. Now, let me tell you exactly what I'm watching for in the next 30 days, because 3 specific developments will tell us where this case goes. I'm tracking 3 specific developments over the next 30 days. Each one will show the prosecution's strategy. First development, grand jury activity. If we see new witnesses subpoenaed within the next 2 weeks, that's a signal prosecutors are building toward additional charges based on her evidence. I'll be watching court filings for subpoena records and witness lists. The pattern tells you everything. More witnesses means more counts. Second development, defense response. The defendant's legal team will almost certainly file a motion to exclude her testimony at trial. That's standard defense practice when a cooperating witness comes forward. But here's what matters. The motion will show which pieces of evidence worry them most. If they focus on attacking the recordings, it tells me the recordings are damaging. If they focus on challenging her believability, it tells me the documents are solid. Defense motions are a roadmap to prosecution strength. Third development, immunity agreement finalization. The proffer is step 1. Full immunity requires a signed cooperation agreement. That's a formal contract between the witness and prosecutors that says exactly what testimony is required and what protection is given in exchange. When that document is filed with the court, we'll see the complete terms. Full immunity from all related charges, partial immunity for specific conduct, or use immunity that only protects the testimony itself. The Supreme Court didn't write an opinion because the law was already clear. Spousal privilege can be given up. Evidence will be heard. No one is above the law, not through wealth, not through privilege, not through endless procedural appeals. The system worked today because the court followed the rules. Subscribe to follow this trial to the end and let me know in the comments which of those 3 developments do you think will matter most? The grand jury activity, the defense motion, or the immunity agreement? I read every one. Now we just saw the cooperation agreement, but that's nothing compared to what she actually said under oath. Reports suggest the sealed transcript has emerged. I reveal what sources indicate were her exact words about the financial allegations in this video right here. You need to see this. Click it.